Good morning, good morning, good morning, law nerds, and hello, replay crew. Remember, everything will be timestamped down below. So if you're like, I just want to get to thing, it'll all be timestamped. And you'll never miss a live stream if you have the Law Nerd app at lawnerdapp.com. So what are we doing today? Well, as much as I avoided yesterday's hearing, which is what we're going to cover today, I couldn't help but seeing the headlines. So apparently Karen Reed sues everybody, but that's not all of what's happening today. Today, we are going to court, which again, I say this now and 15 minutes later, we'll get lots of questions, but today is Tuesday, September 23rd. Yesterday was Monday, September 21st. And Sunday, do you remember? Yes, I know. But on Monday, Karen Reed, her attorneys, and the civil case were in court. If you need a refresher on the civil case, don't worry, I've got you. We're going to do a bit of a road so far before we go to court. And then we will cover the court hearing from Monday. So good to see everybody. Glad you're all here. My kids used all of the milk in the house, so I couldn't make like a cappuccino this morning. And could I just drink coffee? I mean, I don't even know anymore. So Starbucks, Dr. B picked up Starbucks. Very excited. So we're going to break down this hearing. We'll do a little bit of a road so far. For all of you that have reached out and messaged about Monday's episode of The Emily Show, thank you for all the feedback. Y'all are with me on the what up, Ticketmaster. All of you are with me. So, Monday I spent the day being like, whatever, Ticketmaster, in stronger language than that. And then MCR is like, we're coming to Nashville. I'm like, God damn it. Stop it. Am I going to buy concert tickets? I'm going to buy concert tickets. For all of you that have not yet seen Monday's episode, I cover the Ticketmaster lawsuit, which might be the best one so far. And has the most probability of success. Y'all need a deep dive of that. So we'll do a deep dive on another day. I was going to do a whole music lawsuit. I didn't expect that music lawsuit or music day would involve the David case. That is, or as the news calls it, the D4VD case. We talked about that on Monday. We talked a bit about the Karen Reed civil case. We talked about Dever, never going to be a cop again. We talked about that too. So if you missed Monday's episode and are like, how do I not know about these things? LawNerdApp at lawnerdapp.com. Just LawNerdApp at lawnerdapp.com. That's all. And we got you. All right, chat. Are you ready? I understand this. I was seeing La Chancela. I probably got that completely wrong. Love the beep beep on the Jeep. I want to go see MCR. They're not coming to Washington. May have to travel to catch them. We traveled to catch them. It's always difficult to travel for a show because if something happens to the show, you have traveled. But it was 100% worth it. We traveled this time. And it was 10 out of 10. 10 out of 10. They're playing 3 nights at the Hollywood Bowl, though. Here's my beef with the Hollywood Bowl. Emily, you have beef with the Hollywood Bowl? I do have beef with the Hollywood Bowl. Here's my beef with the Hollywood Bowl. The speaker system, unless they have updated it, which is always possible, but highly doubt, the speaker system is not loud enough for a rock show. It wasn't loud enough for a Dave show. It's not loud enough for an MCR show. It sounds wonderful for a symphony. It does. It's lovely when they do movies plus orchestra. Like if you're just giving me the Vitamin String Quartet version of MCR, 10 out of 10. But it's not loud enough for a rock show. Get more speakers. That's all I'm saying. I want to, maybe this is just me. I want to feel my organs vibrating. So loud music, Emily. So loud music. Ear protection, but loud music. The Hollywood Bowl is not the ideal venue for a rock show. It needs to be louder. Like ear protection, but I want to feel my organs vibrating. My soul. So I just, I want to fall in love at a rock show. Sorry, I've got my Blink-182 shirt on. Look. I want it to be loud. The Bowl's not quite loud enough, but 3 days at the Bowl sounds amazing. And all of you are like, yes, I need to feel it in my bones. Yes, I need to feel it in my soul. I need it to it's a sound bath, folks. We need the vibrational energy. Who said Emily D. Bass? 100%. I want to feel it. All right. Tammy said the last time I went to the Hollywood Bowl was just for a comedy show, and that worked. It's perfect for that. It's perfect for that. It is difficult for rock shows at the Hollywood Bowl. I mean, that's aside from traffic and tunnels and LA in general. I get it. I really enjoyed Alpine. Alpine is literally on the side of a mountain. We'll have to tell the story about going to Alpine another day because it was cicada season and one of my friends from California came with me and that was a new experience for her. So that was delightful. All right, let's roll the intro. Let's figure out what's going on with this civil lawsuit. Let's figure out what's with these headlines about Karen Reed suing everybody. Thank you all for those of you that watched this yesterday because I know some of you did for no spoilers. It's okay to sit there and be like, ooh, I can't wait. I can't wait. That's fine. But no spoilers. Thank you. Cheers. Some of you are saying in Cali, we do have cicadas. Okay. I should say my friend from Los Angeles because I have never seen a cicada in Los Angeles. But all of you who are saying Red Rocks is life-changing, it is one of the places I want to get to a concert for. It is on my list. There are some venues. I'm like, I don't care who's playing. I want to go to this venue. I got it. All right. We're going to do a road so far. We're going to find out what's going on with the civil case. We're going to go to court. We're going to watch all of court from yesterday. We got it. Let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I'm here for Emily D. All about that bass, no trouble. Some of you are asking if I got a haircut. Yes, but you wouldn't have known it because my hair has been up in a bun for months and months and months. But we refreshed the color. It's a bit ombre. It was time. It was time and trials finally ended so I could make time. And then I was going to a YouTube event and I was like, I can't go talk to the CEO of YouTube and all of this C-suite execs who I adore with my hair looking like I've been in trial for months and months and months. I just can't. I try not to judge the lawyers when they've been in trial for 4 weeks and their nails are you can tell that the gel is at the tip of the nail. I have no judgment. I get it. Being in trial is hard, but I was like, we need a refresh. So that's where we're at. All right. It's going to end up in a clip in a few minutes because you know how we feel about hair being down. But let's talk about the Karen Reed civil case because we are shifting gears. We have talked about trial 1, trial 2. We have talked about the fallout from the trials, the jobs, the transfers, the discovery in other cases, in the King case and the Walsh case and more. We've talked about all of that. We have covered the initial complaint in the civil case, but it was a minute ago. Remember, this was initially filed in August of 2024 before the second trial went to trial. So after the first trial, before the second trial, and then it got stayed in the middle. And we covered some of that. The reason there are a lot of counts, because when we get into today's motion to dismiss, you're going to hear about some of the counts that are 10, 11 plus. It's because in this lawsuit, the plaintiffs are, you know what, Emily, just put it on screen. It's going to be easier. Why are we not we have the capability, just put it on screen. We can talk about it again real quick while we're doing the background. All right, here we go. So these are all of the parties. This is all of the parties. Paul O'Keefe as personal representative for the estate of John O'Keefe. And then Paul O'Keefe in his own individual capacity. So those are two separate plaintiffs representing the estate of John O'Keefe and himself. And then you have John O'Keefe II, which is John O'Keefe Sr., I guess technically the second, but John O'Keefe's father, Margaret O'Keefe, the mother, and Margaret O'Keefe as grandparent and guardian of Kaylee, who is now an adult, then that is against not just Karen Reed, but against C.F. McCarthy's, Waterfall, and Karen Reed. So we have numerous plaintiffs, we have numerous defendants, and not all counts go to everybody. So when you look at the counts in this, we're going to zoom real quick. We did do a breakdown of this. I'll put together a civil case playlist because it looks like we're going to need it as we go forward. But count 1 is the estate of John O'Keefe versus C.F. McCarthy's. Count 2 is the estate of John O'Keefe versus the Waterfall. Count 3 is the estate of John O'Keefe versus Karen Reed. So you see how you end up with so many counts is because you end up with, one plaintiff versus each of the defendants individually. And in Karen Reed's motion to dismiss, she has gone after not the wrongful death cause of action, but others, and the bars have joined with her. So we will hear from the lawyers from C.F. McCarthy's and the Waterfall at this hearing today, I suspect. Count 4 is grandmother Margaret O'Keefe versus C.F. McCarthy's for NIED. Count 5, John O'Keefe versus C.F. McCarthy's NIED. Count 6, Paul O'Keefe versus C.F. McCarthy's for NIED, the negligent infliction of emotional distress. Count 6 of Margaret O'Keefe, again, John O'Keefe's mother versus the Waterfall for the same cause of action. You see how this is going. John O'Keefe, the father, against the Waterfall. Paul O'Keefe against the Waterfall. Margaret O'Keefe versus Karen Reed for negligent or reckless infliction of emotional distress. John O'Keefe versus Karen Reed, same. Paul O'Keefe versus Karen Reed, same. So this is where we're getting into those additional claims. And then the niece versus Karen Reed for that negligent or intentional infliction of emotional distress. So those are the causes of action that we're going to hear about today because they are going to be doing scheduling. And then they said Rule 12 hearing, which should be the motion hearings. So I expect they'll at least get into the motion to dismiss. I'm not sure that they will get into a ruling on the motion to dismiss. I wouldn't expect that. I wouldn't be anticipating it. Bobby said if she was found innocent, she was found not guilty of all counts but the DUI. Why wouldn't these be automatically dropped? They are a completely different set of laws and rules, and it's a different standard. So when we talked about it in the podcast, we talked about the O.J. Simpson case where he was acquitted of the murder, but then found liable for the wrongful death. The standards are different. The court systems are different. And what needs to be proven is different. And this is all, no, not all, mostly connected to the DUI. So this is mostly connected to the DUI. All right. So Justine, a lot of you have asked, why is John O'Keefe's niece in this and not the nephew? I do not know why. That's not true. I do not know why because I have not said it, but here is my supposition. Because John O'Keefe's nephew was not home that night. He was at the friend's house. It was Kaylee who was woken up by Karen Reed, Kaylee who was asked to help call Jen McCabe, and Kaylee was involved in all of that. So the nephew, I imagine, stayed at home, didn't go to the hospital, and wasn't exposed to the stress and trauma of Karen Reed at the house freaking out that John was dead, which is what the cause of action as to Kaylee goes to. So the nephew not being home is a big part of that. So with all of that, are we ready? Hopefully that makes sense. So with all of that, the nephew was not home. And the niece's cause of action seemed to be the conversation with Karen Reed. I wonder if we'll hear more of that in oral argument today when we go to court. And then as we go to court, I'm going to hold on to questions as we get through this, but we're going to go to court. So, Allie Bewitched said, seems a bit redundant. What will this solve? It doesn't bring John back. It does not bring John back, but what we see in a lot of civil cases is people still don't feel like they have answers. And if you feel like you don't have answers, litigation is one way to try to get to answers. And so the discovery process is a way to try to get to answers. I talked about this on the pod Monday. I don't see how these parties resolve because both of them are kind of locked in. So these parties should have answers. You know where I think those answers should come from. I don't think Karen Reed has any additional answers because I don't think she remembers a lot of that night. So that's what she said in her interviews. All righty. Are we ready to go to court? I'm ready to go to court. I can't say bring the jury because we're just at hearings. There is no bring the jury. I'm putting up live court. Yes, this hearings from yesterday. We're watching it, well, live, but not in real time. Time is a construct. Who knows? I've been on the side of Instagram where it's telling me that half of y'all aren't going to even be here the rest of the day. So who knows? We all still seem to be here. So life is short. Time is a construct. Let's watch. All of you are on the same side of social media as me, right? Are we all in the same place? Have we? I woke up this morning and I was like, oh, my family's not here. I slept in today. Apparently the rapture is today. I think we all know that it's today, so it can't be today. So we're just going to go to court. And some of you have said, do we need to fly to Massachusetts? That's an excellent point. We do need to fly to Massachusetts. The only flights we're catching today is Air EDB. So cheers, everybody. It's enjoy the day and let's go to court. So it's time to Air EDB. Are we ready to go to court? Let's go to court, everybody. Let's get the volume turned up. Look, I don't know what microphones they use in court, but they are potatoes inside a tin can. I don't know. We do our best. But Lord.
All right.
That is way aggressive. It really does sound like they're holding court inside of like a bathroom.
Good afternoon, Your Honor. Good afternoon, all. Before the court is 2483 CV 692. This is the case of Paul.
And remember, we are in a different courthouse, different jurisdiction. We're in Plymouth this time. So we're in Plymouth. So different court, different parties, civil case.
O'Keefe et alia versus C&C Hospitality, LLC, DBA, CF McCarthy et alia. Case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with...
Rule 12 is the discovery motions we talked about. So motions that are still on the docket that haven't been taken care of. And status means they're going to do all the things and set all the things. So now they're going to call all the different lawyers. So Emily, which lawyer is this? I have no idea. So we're going to let them introduce themselves and we're going to forget a couple times.
Plaintiff's counsel, and if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Okay, good afternoon.
So those are the lawyers for the O'Keefe family and all the different ways the O'Keefe family is present in court.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed. Okay, good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Holy shit, counsel. Do we need 7 attorneys in court? Can we just do one? No?
Good afternoon.
Good afternoon, Your Honor. William Kevel on behalf of Karen Reed.
They almost have enough people to play a water polo game.
Okay, good afternoon.
Christopher George on behalf of the defendant, Karen Reed.
There's more? Wow. Hey, wait. I recognize the tech intern from the trial. How are there still more lawyers? They do have enough for a water polo team or rugby sevens. That's a lot.
Your Honor, Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay.
That's a lot of lawyers.
You say Waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor. Attorney John Gilly, also on behalf of Waterfall Bar and Grill.
No wonder all the lawyers have to sit in the jury box. All the other lawyers don't have a seat because Karen Reed's lawyers are like a 7-nation army. What? They do. They have enough to play rugby sevens, but they don't have a lessee, so they're not going to be very good at rugby. That's a lot of attorneys. A lot of attorneys.
Good afternoon, Your Honor. Lincoln Rose on behalf of the defendant, C.F. McCarthy's.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all were going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going.
So the court's like, where we at? Where are we at, everybody? What's the status? What are we doing? But remember, though this case was assigned to the judge, it was largely stayed until we are done with the criminal trials. So it was largely stayed. So they have just really resumed the case.
Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least you get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are, it is significantly deficient at this point. We're still waiting for
Is anyone shocked? Is anyone shocked? Anyone shocked that the discovery from the DA's office is late? Anyone?
Records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation.
That's appropriate, by the way.
Okay. But
the DA's office not turning stuff over while the criminal case is going on doesn't surprise me. That really doesn't surprise me that they were like, you know what? Your civil case is going to have to wait, and you're going to have to go through the proper procedures. So this is the O'Keefe family asking for discovery. I'm not surprised that the DA's office was like, this just has to wait. You're just going to have to wait.
Just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay, so it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants. That's going in a different direction, but you're pursuing that sort of on your own?
Right, but I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So
I don't know if you're entitled to all of it,
that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office.
Well, that's good.
In parts, and I anticipate we should have it all within the next 21 days, is my guess.
Well, then that's not terrible.
All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor.
So the case was stayed. Discovery is starting to come in. They're starting to get discovery from the DA's office. It's going to take some time. You are dealing with a different set of rights in a civil case than you are in a criminal case, and the criminal case getting done first. It's not like the DA's office hasn't been busy with discovery issues. So I'm not shocked that this is at the back of the docket, you know? All right, this is Karen Reed's head civil attorney.
As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf.
Defenses or
Those
claims?
claims stem from the same facts that I'd issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point.
Oh, this is why everybody's saying that Karen's going to sue everybody. They don't mean affirmative defenses. They mean affirmative claims, like other causes of action. That means other parties that aren't involved. That means suing more people.
Including the Massachusetts State Police.
How?
Lieutenant Brian.
How are you going to sue the Massachusetts State Police inside of a wrongful death action? I mean, I think you should sue them. I don't know if you're going to be able to sue them in here. So he's telling the court, we have more claims we want to bring in this suit. So it's like the O'Keefes versus Karen Reed in the bars, and then Karen Reed versus the world. All right, let's hear how he explains it.
Stem from the same facts that I'd issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity,
oh boy,
Sergeant Yuri Buchanan in his personal capacity, Michael Proctor.
Of course.
Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers.
I get it,
We
but
also intend...
there's more? I get it. I don't know if the court's going to allow it in this lawsuit. It might be that this case gets filed separately and it gets put together. But this is difficult to bring the civil rights into a wrongful death case. But he's saying that there's more. So he's saying we intend to sue in our affirmative claims Massachusetts State Police, Tully, Buchanan, and Proctor in their personal capacities for conspiracy and violations of civil rights, which is like your 1983 claim.
Your Honor, to bring claims, affirmative claims against Brian Albert, Nicole Albert,
oh boy,
Matthew McCabe, Jennifer McCabe, and Brian Higgins.
What,
who
everybody?
were the occupants of 34 Fairview Road in Canton on the night in question.
So all
Those claims will be...
all of the adults that were in the house, all of them, everybody that was at the party. We're suing everybody. Brian Albert, I'm gonna back up and let him list this again. So all the adults?
Claims against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins.
Oh boy.
Who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port.
That's fair.
Asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order
That's
for
going
us
to be a tough sell.
fairly defend Ms. Reed in this case,
he's going to make the argument for this sell. He's letting the court know this needs to be filed in a motion, but he's letting the court know, hey, we have a lawsuit and we're going to sue Massachusetts State Police, Canton, Tully, Proctor, Buchanan, Brian Albert, Nicole Albert, Matt McCabe, Jen McCabe, and Brian Higgins. We're going to just sue everybody. And we want to do it in this lawsuit, in the wrongful death suit, which would derail the wrongful death suit. I imagine that the plaintiffs will have strong objections to this. That doesn't mean, if the court doesn't allow them to bring this in to the wrongful death suit, it doesn't mean that they're not allowed to file it. That's a hard sell in a case that's already been ongoing. I mean, albeit barely, to bring in that many additional parties. But you could not join them, but you could make them related cases and keep them with the same judge. It's interesting that they also want to bring a civil rights claim against Brian Albert, Nicole Albert, McCabe's, and Higgins. Interesting.
Those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is, we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in.
Yeah,
to do that, we would be alleging that the individuals in the house diverted attention away from themselves towards Ms. Reed.
It's like obstruction?
That law enforcement then acting on that diverted attention away from her, because the people in the house were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the house was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is, for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed. Regardless of how the court decides those, we still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading, serve all of those new parties with that complaint, allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention.
I think every lawyer in Massachusetts must have been getting phone calls yesterday, because this streamed yesterday. And though I think there's been lots of discussion about whether or not the McCabes, the Alberts, and others would get sued, this lawyer is standing up in court saying, oh, by the way, we're going to sue everyone. Get ready. We're coming for you. It's a full, name them. We're all of them. We're all of them. And he wants to bring them into this lawsuit, into the wrongful death suit, which embiggens this suit substantially. So that's what he's telling the court. Hey, we would like to do this, but we're giving you a heads up, because we're not just going to cram 10 more parties into this. Little White Lie in the chat said 10 million butt dials currently happening. Yeah.
I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process. No. But go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claim should
Which
be
puts
in
them
this
together
case.
anyway.
They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
I mean, I get that. He's saying essentially their defense to the wrongful death is we didn't cause this, and we don't know who caused this, and we don't know who caused this because of what they all did. So it's on them. The distress was caused by these other parties not investigating, not diverting attention, and all the rest of it. So these other parties are really the problem. I mean, this is going to take, this is, adding 10 parties to this case is going to be wild.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff. We're under extension until next month. We anticipate that that will be completed then. We as well.
When you say an extension, this is an agreed to extension?
Agreed.
Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at deposition.
Tracking order, for all of you asking, scheduling order, like days, deadlines, when you need to file motions, replies, oppositions, disclose experts, those sorts of things. So tracking order, scheduling order, when shit's happening.
But we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right. Thank you. Let's hear from C.F. McCarthy then.
Thank you, Your Honor. Your Honor, we're in a similar boat as to Waterfall. We are putting the finishing touches on our discovery responses. The last leg of it is just collecting communications from employees the night of the incident, some of whom no longer work for C.F. McCarthy's, but we anticipate having that completed in the very short term and getting that over to my brothers.
Okay. All right. Thank you. Let's hear from the plaintiff.
Massachusetts is a jurisdiction that refers to colleagues or opposing counsel as brothers and sisters at the bar. So that's, he doesn't mean his literal brother. He doesn't even mean like his play brother. It's just different courts, different quirks.
Plaintiffs then, in terms of response to the procedural issue that was raised in particular by Ms. Reed's counsel, are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Probably not.
Absolutely not, Your Honor.
The first notice you've gotten?
Of course, I would.
Not how the court system likes this stuff.
Ooh, I'm going to back that up because I was laughing. The judge is salty. The judge is salty. So this is now the O'Keefe's attorneys. And the court's like, y'all know about this? And he's like, nope. And the court's like, this isn't how I like to do things. Ooh, the judge is cranky. Already cranky.
Counsel, are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your Honor.
The first notice you've gotten?
Of course, I would expect.
Not how the court system likes this stuff to work, folks.
I would expect the courtesy of a meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Dilla is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action.
We're going to have to go in between somewhere.
Our narrative of what took place.
But it is, though. It's the plaintiffs. Well, just hear me out for a second. When you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right?
Right.
So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the...
So the lawyer just broke down what he's trying to avoid. And the procedure that he's trying to avoid is filing notice that somebody's going to be brought into a case, and then they oppose it, and then maybe they get brought into the case, and then they oppose it again, and back and forth and back and forth. He's like, Your Honor, it will take forever to do that with 10 parties. Because if you don't think that everyone's going to fight every step of the way, I think we are, improperly perceiving it, because I imagine everyone will fight every step of the way. I liked his first proposal better, which was just file the lawsuit and then make a motion to consolidate. And then once you make the motion to consolidate, then there's only one round of oppositions. It kind of streamlines it, but he's asking the court to use the court's discretion and say, hey, Your Honor, instead of we give them notice and we try to pull them all into this lawsuit, we're asking you to use your discretion to kind of streamline that. I think that filing the additional lawsuit and then consolidating it might be easier. I wonder if the reason that they brought this up now instead of in written motion is to bring everyone's awareness to what is going on in court. I just have to wonder. Because, now everybody knows, right? Interesting. This is going to be lots of litigation. Woo, boy.
The status conference, so that because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Dilla to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case. Correct?
Yes, Your Honor.
There's 5 for the plaintiff and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way
there's already 8 parties. They want to add 10 more. And the judge is like, I really want to set a trial date. Oh, Your Honor, that's adorable.
Case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has.
I know they said it fast, but did you hear those dates? Did you hear those dates? Resolution by June 2027. They are optimistic that they will have resolution by the summer of 2027. That is what they're hoping for. Those were the dates. Middle of 2027.
In store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date.
I appreciate that whatever Karen Reed's skincare is that has her skin being poreless, like I'm here for it, but can we just watch the judge talking and let the woman just be in court? But yes, for all of you being like 2027, yeah, wild. However, not unexpected for civil cases. Not unexpected at all. Civil cases in particularly Los Angeles County and elsewhere are already getting set into 2028. It is just the civil court system is way backed up.
Soon as practically this spring on this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative pursuit.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses.
No.
Those are wholly separate third-party.
No, he didn't say affirmative defenses. He said affirmative causes. He did not say affirmative defenses. I was listening to hear if he was going to say affirmative defenses. He didn't say affirmative defenses, not once.
Causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
Your Honor, I swear, if you set this case for another April and we spend another April, May, June, July in another, I just can't. Can we just not?
Not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. I don't know
if he's going to consolidate them.
And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But to have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense.
It's fair to have them as related cases because it doesn't make sense. He's right. It doesn't make sense to depose Jen McCabe twice. it does make sense to do the depositions and to share some of the discovery. It doesn't necessarily mean they need to go, that they need to all be in one trial versus being related cases that are in separate trials, but whatever. All right, can we not look at the audience and just look at who's talking?
That's why we're raising.
This is one of the plaintiffs, Paul O'Keefe.
We'd like to brief it if the court
John's
gives us that permission.
Okay. All right. Now, on that last discrete issue,
And
anything else from
John's
the
mother.
plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide-ranging as they've just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
Okay. All right, those issues are reserved. I certainly am not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the...
The court has unsaltied himself. Did you hear that? The court said, I appreciate hearing about it. There's nothing pending before the court. And I think that's the point of the lawyers. Your Honor, there's this massive fucking thing that's coming down the road. And instead of just like springing it on you, I'm going to make sure that you are aware and we're going to give you the heads up. And the court has come back around from salty to, I appreciate the heads up. I mean, this is much, but I appreciate the heads up. And I think the heads up is appropriate because you don't want to file something and have the court go, what the fuck is this? Because this is not a little ask. This is a lot of an ask.
Future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor.
So it sounds like we're going to get into the motions to dismiss. I'm going to go ahead and give a swoop as we got from the status conference. And a status conference is a time to bring up, hey, Your Honor, this is what we see happening with the case. We're gonna sue everybody. So just a heads up. We have 8 parties in this case. We want to bring in 10 more. So this is going to be everybody catches a lawsuit. And we suspected that was coming. Everyone has suspected. And I think in interviews, I have not watched all of the interviews the attorneys have given, but I think in interviews we have seen very strong alluding to the fact that there will be civil lawsuits in this case. And we heard at the beginning of court in the civil case that Karen Reed intends to bring lawsuits against Massachusetts State Police. Is anyone shocked? No. But suing a government entity takes on a little bit of a different character because there's procedural steps that have to happen first. So suing Mass State Police, suing Canton for not securing the Sally Port, suing Trooper Tully, Buchanan, former Trooper Proctor, in their personal capacity, and then suing those that were in the house at 34 Fairview, Brian and Nicole Albert, Jen and Matt McCabe, and Brian Higgins. So all of those parties, Karen Reed's attorneys have lined out for the court. We intend to sue them. Now, the O'Keefes are like, hold up, we sued you. Can you please not also turn around and sue everyone and bring everyone into this? Karen Reed's attorneys have said, look, instead of doing 2 depositions with these parties, Jen McCabe, whoever, we should just do 1 deposition and streamline these cases. So whether down the road these will all be one case with counter claims, meaning one jury will hear all of the cases. Can you imagine? Oh, the verdict forms make me want just immediate heartburn. Immediate heartburn trying to look at what a verdict form in a civil case would look like to determine liability when you have the O'Keeffes suing Karen Reed and the bars, and then Karen Reed suing everybody fucking else. And I imagine for the O'Keeffes, they're like, we don't want the decision about the wrongful death to also include decisions about what all these other people did. And I imagine for Karen Reed, it's like, you can't talk to me about the wrongful death until we talk about what everybody fucking did. So whether they end up as a joined case, a related case, if it is just a related case, it's two separate cases, two separate juries. If it becomes a counterclaim case, then it becomes one jury and a whole bunch of different stuff. Go a whole bunch, which means this case will take so much more time. But the court's like, hey, we got nothing but time. We could go to trial sooner. So we'll see. All right, let's get back to court for the motion to dismiss. I was gonna do a swoop, and then I soliloquied instead. So now we will swoop. And now we will go back to court. I appreciate the artistic blur on the camera. I do not appreciate that they just keep zooming in on everyone in the gallery. Just court and the media would get along so much better if they just focused on who was talking. They really would. They really would.
As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, the counts 10 through 13. Right. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged.
Counsel is giving the position for the court, talking about the causes of action that they are looking to dismiss. The causes of action they are looking to dismiss are the infliction of emotional distress claims. So that is what they are going to focus on. They are not trying to get rid of the wrongful death. They are not asking to dismiss it. That has been properly pled. Remember, the standard at a motion to dismiss is everything taken in the light most favorable to the opposing party, which means in this case, the light most favorable to the plaintiff. If you look at everything they said, take it dead ass as true. Emily, are we just going to Gen Z-ify law at the moment? I have a 13-year-old, yes. We can fight over whether that's a Gen Z or Gen Alpha term another day, but the court has to look at everything pled as if it is facts. And then from that perspective, do the things in the four corners of the pleading state that there is a cause. It's not, well, these things aren't true, those things aren't true. It's, Your Honor, if everything they said is true, there is still no cause of action. So that is where the motion to dismiss is. And that is why they are bringing the motion to dismiss on the infliction of emotional distress claims. And that's why they are narrowing down the motion to dismiss on the negligent / intentional infliction of emotional distress, right? All right. So that's what we're going to hear them arguing about. Because now we're hearing the motion to dismiss argument because Karen Reed brought the motion. Her attorneys go first. The bars joined in the motion. So we'll see if they hear it or if they say anything. I don't know how much they'll say other than joining in the motion is what he says, me too. Like what he says, we agree, us too.
Incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, That claim is for negligence/reckless/intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is pled in the complaint, that would satisfy the limitations that the case law sets up, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event.
Many of you are asking in the chat. I am not a linguist by any means, but to me, based on just personal experience with people in my life, he sounds South African to me. Most of you in the chat are like, he also sounds South African to you. So, maybe he could carry the rugby team if we have a sevens team with these attorneys. Also, if all of you were like, who's squeaking? I was squeaking. I'm like, I don't love some of this. The arguments, some of the arguments about the niece, I understand the legal argument, but some of the arguments as to the niece, like I get it, but I don't want to be the lawyer that is standing in court having to make that argument. So all of you are like 100% South African. There we go. Well, so all of you who love his accent, look, we are definitely simps for a great accent. We are here for it. And it'll be nice to hear someone say C.F. McCarthy's and Waterfall in not a Boston accent. Like Boston plus South African is going to be fantastic. I'm here for it. I'm here for it.
They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly.
We saw some of these difficult arguments to navigate with wrongful death. Like you have to take the emotional, like human side out of the arguments and look at it fairly coldly legal. And we did that when talking about the Gabby Petito, Brian Laundrie civil suit between the parents and talking about where it falls with the emotional distress and negligent or intentional infliction of emotional distress based on what was said, what wasn't said. And in that case, we were talking about where are the boundaries of negligent infliction or intentional infliction of emotional distress. And this is what this attorney is saying. He's saying, look, the wrongful death statute encompasses, and accounts for the trauma, the distress, the loss of that person. But these statutes for the infliction of emotional distress do not accommodate for that because the events that caused the distress are not the type of events that the law accounts for. And the case law, in fact, says that these are not close enough in time, that these are too distant, etc., and that it's all really subsumed into the wrongful death cause of action. So they're saying the IIED claims or NIED claims should just go, and that those should be taken out, and you just leave the wrongful death claim that covers all of it. So that's where the argument is about the distress.
In our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can.
This is from the bars.
Yes, Your Honor. On behalf of Waterfall, just very briefly, I think the distinction here the counsel's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're percipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't, from a relational standpoint, close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of a son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss?
No, Your Honor.
No? Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
You know, allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that, but I want everyone who's sitting here to.
The court was trying to set the stage for what he was doing, and plaintiff's counsel are like, well, do we get to be heard? Obviously, you're going to get to respond. I don't know why he's cutting off the judge while the judge is explaining what's happening. I hate it when people cut off the judge, which, as an ADHD interrupter and someone whose brain wanders, like it sprints away if someone talks too slowly, the cutting off the judge is just like, oh, don't do that. Don't do that. Don't do that. Gosh. Emily, you always say you wouldn't want to be a judge. Yeah. Because if somebody cut me off twice while I was sitting on the bench, I'd be like, look, man, my cats don't listen to me, but you're sure as fuck gonna. So don't interrupt. And that's not appropriate. The orange cats can get away with it. Counsel, you cannot. You're not cute and fluffy. So I backed this up because I wanted to hear what the judge was saying before counsel interrupted.
Motions to dismiss?
No, Your Honor.
No? Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
You know, allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint.
Teaching the audience.
Those allegations for purposes of a motion to.
Okay, so the court's now explaining to the viewing audience, Your Honor, you're coming for my job. I'm here to explain. I appreciate it, but the judge seems like he is looking out to the audience, explaining what the motions are.
Dismiss have to be accepted as true, and the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motion to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss, the lowest standard, the Brum case. Plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants fail to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his
hate it when lawyers do this.
nephew.
I hate it when lawyers do
no
this.
longer has a voice.
I hate it when lawyers do this. I hate it. I continue to hate it. I hate it less when it's the plaintiff's attorney because there is a claim brought by the estate, but we're in court. Just refer to people by their last name. And if there is confusion because there is John O'Keefe II and John O'Keefe III, then refer to one as Mr. O'Keefe and one as John O'Keefe. But the nicknames I don't like it in court. I don't like it.
His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's...
Why are you filibustering in your motion to dismiss? None of this is relevant to the motion to dismiss. I don't disagree with you. John O'Keefe shouldn't have died. John O'Keefe seemed to have been stepping up for everything that was thrown at him by life. And his loss is a tragedy, absolutely. But there's no way that that is part of any of the motion to dismiss. A wrongful death suit doesn't turn on the relative value of a victim. That's not what the suit is about.
Older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned.
Yeah, all of that's
JJ
tragic.
stepped up. He agreed to parent those children, to raise them as his own, and to support them.
None of this is
Fast forward to
relevant.
2022, Your Honor.
It is tragic.
JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or call.
I mean, you're going to have a real hard time proving that. The drove drunk, I don't think you're going to have a hard time proving. But after that, you're going to have to real hard time proving it. I am trying not to yell because the court is required to take all of the allegations as true. It is much easier in a civil case that we don't know, right? It's much easier in a civil case that we have no background in to say, the court has to take all of this as true. It is intellectually substantially more different to say, the court has to take all of this as true when we have sat through 2 trials. It is intellectually more difficult, but the court has to separate it. Y'all don't. You can all just be like, The court has to accept what counsel is saying of the facts as true. It is very frustrating, but we are at the motion to dismiss stage. The legal standard is if the things written in the lawsuit are true, then is there a cause of action? That's it. It is a very low standard on the motion to dismiss. This is not summary judgment. This is not anything other than like legal magic words. Did you say the things that make this a cause of action? Yes or no? That's what the motion to dismiss is. More difficult, given the fact pattern of this case. So hang in there, everybody. That's already annoying. I know. It's just, okay. Oh, we've got like another at least 30 minutes of this hearing. Okay, everybody. All right. Woosah.
911. She returns to JJ.
I broke up his sentence. I don't know if it matters, but woosah.
Reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost.
I'm moving my head because I wanted to see co-counsel's head. But y'all, this is motion to dismiss. This is motion to dismiss. It's a motion to dismiss.
2 parents, tragically, and 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic.
That timing's right.
She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? all to a 14-year-old child woken up from sleep who's already lost two parents. After provoking this chaos in the middle of the night, Ms. Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness. At or around 6 a.m., they rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while...
You're not suing for that, though. That's not part of any of these claims, though. This litigation's never going to end.
Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute.
He did say that.
We reject that argument.
We're back to legal arguments.
JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out, first, the wrongful death statute, it has two components for damages. It has two buckets of damages. It has the estate's damages, those.
They're not fighting the wrongful death. I mean, they are fighting the wrongful death. They're not moving to dismiss the wrongful death.
Okay. All are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress.
I need more of the facts, though.
The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct.
Yeah,
a claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You are right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino.
Anything.
We ask that Your Honor deny the motion to dismiss for that first argument.
Okay, good.
The second argument that they make, Your Honor,
Not done.
is that the plaintiff's NIED claims are not.
A lot of you have asked for code red. The attorney is doing his job. Some days that is more difficult to witness than other days. But this attorney, this plaintiff's counsel, is doing his job. It's difficult more so than other cases just because so much is known about this case. But yes, I grant you all bruh. Like for sure. We're not at full fuckery. We're at the audacity, the bruh of it all. Because there's a long way to go in this case. And it seems that the plaintiffs are leaning into that Karen Reed was plotting. But just, it's an interesting strategy in light of what has come to pass in the other cases.
Not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. The law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident because let's look at the law itself. The liability for NIED depends on number of factors: where, when, and how the injury enters into the consciousness.
Can someone explain to us how the injury happened? Like with proof? Because if this civil case answers that question, then the time will be worth it. I would like to know.
Of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness.
He's not talking about the point I was making. He's talking about when the plaintiffs became aware. That's what he's talking about. So when plaintiffs and how plaintiffs became aware of the injury, it's different. And this is the part of civil cases and studying civil law for any of you that have, the lawyers in the chat, when you are in law school, the empaths, civil law gets real difficult when you're trying to put like dollar judgment on people's lives. And it's like, well, they could have earned this much throughout the course of their lifetime. And how do you put a dollar figure on loss? But that is so much of plaintiff's work. And then talking about how relatively traumatized is someone if they come across a car accident because they're following someone home and they witness the accident happen. Different than identifying somebody at the hospital or a morgue days later, and then how you start to apportion out legally like what is worse. And for those of you that have dealt with loss is awful. Grief is awful. I don't doubt that John's parents have been through horrible and tremendous amounts of grief. But the law is going to try to figure out where in the chain of events the law stops accounting for that and attributing responsibility to someone else versus loss is hard, there is tragedy, and it is not anyone else's legal responsibility. So that's where apportioning liability starts to get difficult to discuss, and that's what they're discussing now. Because I don't doubt there is horrible and tremendous amounts of grief for the entire O'Keefe family. It seems like there are tremendous amounts of grief for this entire community on many different levels. I don't doubt that John's niece needs all the support in the world because Karen Reed waking her up out of a dead sleep probably absolutely scared the shit out of her and caused her a tremendous amount of distress. But is there legal liability for that or not? And that's where the balance is. So talking about civil law is hard because there is the emotional side and then there is the very cold, calculating civil side. And we're going to try to navigate both. I didn't work in civil law very long because I hated it. I hated all of this. Criminal was different. So hated all of this. How do you put value on grief? Grief sucks. I have soapboxed enough. Let's get back to this attorney in court. But civil law is tough. Sometimes it's just easier to like deal with corporations fighting over money. You're just like, whatever. With this merger, everyone's very stressed, but whatever. This is hard. This is hard. And death and loss is hard. And apportioning one person's grief over another person's grief is hard. And then coming up with monetary amounts for that and finding where in the line of events somebody is on that is hard. Fluorescent said, Emily, now I see why you're so flabbergasted when a judge has to switch between civil and criminal. Yeah, they're so different. And that's just not how I grew up in a different legal system. So it's very unusual to me, but putting your head into criminal law is very different than putting your brain space into civil. The rules are different. The procedural rules are different. You're dealing with different rights. So I think it's a lot to switch. And this judge, you heard this judge say, we have a jury deliberating right now while we're doing this hearing. So this judge has been in trial. It sounded like been in a murder trial. This judge has been in a criminal murder trial. There is a jury behind these walls deliberating, and these attorneys are in there arguing a wrongful death case. It's a wild context switch. And speaking of context switches, let's just noodle back down into this attorney's just arguing all.
It is misplaced for the defendant to suggest that it matters that plaintiffs were not at the scene of the accident, because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress.
Can we just look at the speaker?
Than a plaintiff who rushes to the hospital.
Hi, Jackson, but can we just...
So long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours.
Counsel, you sure about that time at 12:30?
She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they, closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the...
Seems like an odd use of the word incredulous. Or possibly the wrong tense. Something is off about that sentence, but my brain is already a little bit broken trying to listen to this, so I'm a little bit lost on that use of incredulous. Okay.
Of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss.
It's a very different standard.
To overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has...
He's arguing about the case law that counsel has cited. If all of you just went, what the fuck is happening? He's arguing about other case law in counsel's motions. So they're arguing case law. So all of you just went like, what? They're talking about case law.
No relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who bought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body.
They are talking about
contrast that with everything that we talked about, Your Honor,
in the case law,
where as soon as it was knowable, they learned about.
Law is very fact-based. For all of you who are neurospicy, you might also operate this way when you have conversations. Law is so incredibly fact and story-based. It's why I love trial level law. Your Honor, this is the case. These are our facts. Look at these other cases and these other facts, these other things that have happened. This case is more like these facts and less like those facts, which is why in this wrongful death case, they're talking about other cases of wrongful death and infliction of emotional distress. And they're talking about other fact patterns to say, we think it's more like this one. And the other side thinks it's more like that one, but it is all very fact-based on what happened in this case. The court said in that case it was sufficient. So in that case is more like our case because of distance and time, etc. So that's why he's arguing about the Cohen case, which is the plane crash one that he's talking about with regard to intentional infliction of emotional distress. And I do imagine that being 1,000 miles away and finding out something happened when you can't get there is incredibly distressing. That would be incredibly distressing. Sure. But was that claim allowed to go forward? It sounds like it was, and that's why the court is citing them. So that's, if you ever do this in your own world, you're just arguing it like an attorney. You're just like, look, but in this case, this, and this time, this. I find myself doing that all the time when I'm having conversations, and I'm like, oh, I'm sorry. I have spun out into likening it to other fact patterns. Continuing on.
They rushed to the hospital, they saw the body, and they saw
Different
the body
case.
within minutes of him being
Back to this
declared
case.
dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own two eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So
what he's arguing is that the experience that the case law is talking about doesn't have to be just seeing the person injured or seeing the person dead, that you can experience that injury and that trauma and that event through being told about it. That's what he is arguing here.
But second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these
I mean, as to Kaylee, it's a stronger argument. As to everyone else, not as strong of an argument.
Vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship
Camera, can we just focus on who's talking?
Of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities.
It's just fucking weird at this point. Whoever the pool is, stop it. Focus on who's talking. It's just ick. Stop. I hate it so much.
Is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we
I think the argument to Kaylee is their best argument.
Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed the pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down.
The reason they're talking about Kaylee so much is because she is one of the plaintiffs in this case. So he is talking about Kaylee. It is the stronger argument. Notice he has not talked about Paul O'Keefe, John O'Keefe II, which is John O'Keefe, the victim's father, and Maggie O'Keefe. Or Margaret. They have not talked about them as much. They are focusing on their strongest argument. And I think Kaylee is their stronger argument than the rest of the O'Keefes. But I need to look at some more of the case law on how temporal it is, but we'll see.
In the middle of the night, she wakes up
Peggy.
Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has...
Counsel, you have jumped the shark. What are we doing? We have now gone just completely the opposite direction of helpful, because none of this, like, the time has ended. None of this has anything to do with the claims that you're talking about now. You're just like, oh God. Okay. I can only imagine that this is what you were talking to your
fair game
clients about. If you're mad about it, then sue Turtle Boy. I mean, this doesn't belong in this argument. And I'm not suggesting that they should or that they have a case. I'm just saying this doesn't fit here. This is just, well, I guess we're just airing grievances, it seems. So, okay.
She leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative.
I agree with you, chat. You can't leak public information. Karen Reed has the right to speak publicly. This is not the basis of these claims. You're correct. Just correct.
Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game?
What Turtle Boy had to say or didn't have to say, and whether it was said or not, is irrelevant to the O'Keefe's claim against Karen Reed. It has nothing to do with any of this. Truly. Okay.
Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seen before?
That's not the cause of action,
to the extent
though.
that the defendant argues that this is not extreme and outrageous, remember.
You're not suing over the autopsy photos, though. None of this has anything to do with this case, and you can't attribute IIED you can't attribute infliction of emotional distress between the O'Keefes and Karen Reed based on shit that they are saying Turtle Boy did.
Bruh.
The law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law.
Truly, Harry.
As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise.
He actually just brought it back around while I'm still singing the theme song to Gem and the Holograms in my head because cartoons were better when I grew up. I'm sorry to everyone who is younger, though I will say Phineas and Ferb is top tier 10 out of 10. But he brought it back around to the point here being, should the defendant, in this case, Karen Reed, have known that the behavior was outrageous? We saw these conversations when we were talking about the Petito family versus the Laundrie family and talking about their actions versus inactions. Here, I think the argument that Karen Reed said things to Kaylee is a stronger argument than the O'Keefes showing up at the hospital and seeing John O'Keefe's body after he was declared deceased is attributable to Karen Reed. I think they are going to have an easier time down the road proving that the things said to Kaylee were distressing to her and were actually said to her. I don't think they will be as easily able to show that John O'Keefe being deceased was directly the fault of Karen Reed and that she knew, and that she then knew that that would be especially distressing to his parents, because what they are attributing the IIED to John's parents and brother is that he was deceased versus anything that was said directly, which is different in Kaylee's situation. So I think the two situations are different. And yes, down the road, because many of you have asked, and I'm sure will ask, could different parts of this case settle out? Like, could Karen and Kaylee settle? Yes, they could. Because if Kaylee and Karen settled, it would be essentially, yes, these things were said and that caused distress. Those things could settle out separate and apart from Paul O'Keefe, John O'Keefe, father, John O'Keefe's estate, and John O'Keefe's mother. It would just be different. And so I think you have some different avenues based on different plaintiffs and defendants. The defenses or the plaintiffs are, of course, arguing all of it together because, well, that's the role on a motion to dismiss, and the standard for a motion to dismiss is quite low. Did the words you say bring a cause of action? Mari HK said, but does Kaylee want any part of this? We don't know. We don't know. Kate said, is Kaylee's argument built on Karen hitting John? It's more built on Karen telling Kaylee that something horrible happened to John. At this point, that's the way that they are articulating it.
A reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant.
The argument on this is that they are particularly vulnerable because of the loss they've had in their life. And some people walk with more loss in their life than others. But the heart of this is that Karen's legal, civil responsibility.
Always knew this. She has always known their vulnerability. And yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendants should have known would result in distress to the O'Keefe family.
It sounds like they are trying to extend the infliction of distress beyond the hospital at this point in their argument, even though they didn't earlier in their argument, saying that the behavior extends to things that Turtle Boy said, and trying to extend an IIED claim to things that Turtle Boy said is legally just a difficult strategy. I'm going to leave it at that.
To the extent that the defendant suggests that this case sits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of the cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activities.
Counsel, I can't even look at you more sideways without hurting myself at this point.
Because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy.
And, excuse me, and Her criminal cases are over.
HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments.
I don't think Massachusetts has a factually innocent finding, but we've all heard from the jurors in that case. So, okay. Carry on, counsel, just with whatever you're doing.
Know that plaintiff's susceptibility and vulnerability are at issue in this case, and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
I'm sure there is.
Firstly, those allegations.
The defense is Karen Reed's civil attorney. The reason he's talking about the language rude and clumsy versus extreme and outrageous is the case law on these facts. That's in this case actually specific to the claims. So that's why that language is being used here. All right. The response from Karen Reed's lawyer, which I'm sure is going to be like, whatever the fuck that was, half of it has nothing to do with these causes of action. I mean, he's going to say it in court speak. He's not going to say it that way.
From the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see.
The father being in the car is a whole different fact pattern than learning later. An entirely different fact pattern, which is why I said the fact patterns matter.
His son, it's contemporaneous, it's at the time of the event, and the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. You also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor.
And there it is. The plaintiff's lawyer for the O'Keeffes talked about a whole lot of stuff that went well beyond the O'Keeffes showing up at the hospital and seeing John O'Keefe deceased, and John O'Keefe's niece and the distress she suffered when being woken up, and the conversations that happened there, and then Karen Reed calling Jen McCabe, and then the rest of it. And now Karen's attorney is saying, exactly. See? That's why we need everybody. See what they're arguing? That argument is why we need everybody. Everybody. We need everybody in this case because of exactly what they argued. if they're going to go to trial and argue all of this, we need all of these other parties because what they just said. And I'm not surprised that they are taking the opportunity to say, exactly, Your Honor, exactly. That's why we need everyone else. Good argument.
I respect the opportunity to brief that.
He paused.
We rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue?
So Karen's attorney took the opportunity to say, this is why we need everybody in this case. Thank you for letting us brief it, and didn't really argue much more about the motion to dismiss. Most motions to dismiss are denied. So sometimes you'll see motions to dismiss pare things down, but most are just like, yes, this states a claim that is sufficiently pled. That doesn't even get into like summary judgments and things like that. So I appreciate that they took the opportunity to say, see, we need everybody.
Anything else?
Nothing further, Your Honor.
All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought.
Your Honor, they have me, but I
dismissing certain
appreciate
of the
you.
counts
I
that are in this
appreciate
complaint.
you.
And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that it might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that
to all the parties involved, this is the court right now. To everyone involved, look at me. Look at me. This is going to be expensive, invasive, and ultimately unsatisfying. No matter what a jury does, it is not going to change where you're at. It is not going to help. And the process of going through this is going to suck. So, I want you to think about how much of this you want to go through. However, a lot of times, civil litigation, people are looking through the lens of wanting more information. And so until discovery is done, people don't even want to have that conversation about settlement because they want information. And I understand in this case, I can really see where the parties want more information. And I can understand that. I don't know if other litigation would have been more fruitful in that, but we'll see. But the judge, it's not surprising to me that the judge is going to look at all the parties and say, hey, just so you know, which judges do in every single civil case, right? Because sometimes the lawyers saying it to the parties doesn't resonate the same way as the judge saying it to the parties. I mean, the judge in the TikTok defamation case in Idaho has been trying to say that forever. He's not making any headway on it.
Litigation provides. And you know, this is a civil case. It's not a criminal case.
We know.
There are 8 parties, as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so.
They're not even going to get depositions done by then.
We could do it in March. March or April if you'd like to.
Your Honor, we are not doing another Reed trial for the 3rd April in a row. No. Negative. No. They're not going to be ready. They're not going to be done with discovery and depositions. They are not going to do this case in April 2026. I suspect they won't even do this case in April 2027. But no.
But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You've got a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties, and relatively novel theories as I'm hearing it. But nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this.
Give me a trial date.
They can do it by way of potential resolution.
Y'all
and I
settle.
mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you
I don't know if the uncertainty that these parties have can be resolved in this litigative process without other parties. I don't disagree with Karen Reed's attorney on that. I think other parties are necessary to resolve the uncertainty. I don't think the O'Keefe family sees it that way, which I can understand. But other parties are necessary to resolve the uncertainty. So, and for all of you that will ask, okay, I hesitate to even say this. But in theory, could Karen Reed just tell the O'Keefe family everything they want to hear, true or not true, to get the case to settle? Yeah, she can't be brought up on criminal charges for anything related to this case again. But that's not going to happen, because this has all gone too far at this point, I would imagine, from Karen Reed's perspective. And from the O'Keefe perspective, I imagine that they are angry and they want answers. I don't think the answers that they are going to get from Karen Reed are the answers that they're really seeking. I could see, well, it depends on the bar's insurance. But I think the bars have a pretty solid argument that Karen Reed was not overserved based on the evidence we saw at trial. I could see Kaylee and John O'Keefe's niece and Karen Reed settling. That I could see. And I don't know what that resolution would look like, but the problem is, though, that John O'Keefe's mom is the one who is acting as the representative for Kaylee. And so if John O'Keefe's mom is the representative for Kaylee, it becomes a little bit more difficult. But I could see Karen Reed being like, you know what? What does Kaylee need to settle? And can we just put it in a trust for Kaylee and just resolve it? I could see that being an outcome. But as to Paul O'Keefe and Karen Reed, I don't see that ever settling. As to John O'Keefe's father and mother settling with Karen Reed, I don't see that happening either. So, yeah, I don't see how this case resolves. I can see the bars trying to get themselves out of this case before it ever goes to trial. I can see that happening. But this is going to be arduous litigation.
Hope for the best. Lawyers work really hard for their clients.
So the court is saying, hey, you have the ability to settle. Don't forget.
Avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it, and ultimately a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here, clients can ask your lawyer about post-disposition or post-verdict process. It can be really long and arduous.
Years.
I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going.
Your
clients don't have to do that.
It doesn't
end. Clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term.
100% you're going to have to deal with that.
To try to get you what you can as quickly as I can.
Your Honor, please do not pledge us anything. Please do not pledge. Please do not pledge. Please do not pledge anything. It's like, I pledge to get this handled. No. In the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but probably.
I think it's important that
you've read the room.
There is an alternative way out of this.
You've read the room correctly, Your Honor.
Money damages are all the plaintiff can ask for. Nobody can restore. We say this when people lose loved ones or that they have
nothing makes
some
it
meaningful
right.
part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with
what
a
we've
burden
already
of proof
seen.
by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2.
I don't know. You're not, the corporate defendants aside, I think this is probably what this judge says to most parties. I think this would resonate better with a different defendant.
Ongoing.
I don't know if you're going to convince Karen Reed and her attorneys that this civil litigation is going to be more stressful than the 2 criminal trials. It's an unusual situation that this defendant is in, but I imagine that Karen Reed at this point has a Steely-like disposition for being in court after building that fortitude through 2 criminal trials. So I think with most defendants, probably, but with this particular defendant, the stress of trial is something that I think she's used to living with at this point. The plaintiffs, maybe not so much. But this defendant, The court's like, this can be stressful. She's like, I mean, I'm not going to prison. So, okay.
Important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have two ongoing, as far as I understand, the two businesses in Canton are ongoing, and they have their business decisions they have to make ultimately. They're defendants in this case.
Their insurers
they have to understand the risk of going forward.
I mean, that's their insurance
in a trial
companies.
versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that.
I don't know if there will ever be enough answers for Karen Reed and the O'Keefes to ever put this behind them. I don't know how we ever get to a place where enough is uncovered to get some answers. But there are parties missing from the room to get to those answers.
By looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring. Do you want to?
No,
Okay.
Your
Anything
Honor.
else we need to address this afternoon?
Nobody wants to go to trial in April 2026. They
Not
won't
from
even
the
get their
defendant, Your Honor.
depositions
Great.
done.
I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together,
derail everything.
I think that needs to be looked at sooner rather than later. It's a big deal, right?
Agreed.
Yes, Your Honor.
Okay. Why don't we get a status date?
Judge is starting to sound like Mandy Matney. This is a big deal. It is. Bringing 10 additional plaintiffs and 10 additional defendants, 2 of which are government entities, into this is a very big deal. And it will push this case into 2028. It is a very big deal. I'm glad the court's like, we need to get this done sooner rather than later. And when the court issues a ruling on the motion to dismiss, we'll cover it.
When do you want to? And we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet.
Well,
I
that's
want
why there's
people
all
to
7
be,
lawyers in person.
Understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to have seen, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time.
It hasn't been filed
Want to
yet,
do the next
though.
hearing by Zoom? You want to do it by in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do whatever.
We're agnostic? Is that what you said?
Yeah, as it relates to that. We'll come in person or we'll do it by
He's agnostic as to Zoom.
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay.
No preference, Your Honor.
All right, we'll do it in person. Fine. We'll do it down
Great.
here in Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
Okay, what the court just said was, I am moving, because the judges here move circuit, like they move around, which is also some areas do that, some areas don't. Some areas the judge sits in their courthouse. Sometimes they get transferred to different courthouses, but they generally don't just move consistently. But the judge said this case is specially assigned to me, so I will come back to this courthouse for the hearing. Next hearing will be in person, and then they're going to set the next date.
How many days out you want to go, man? 60 days? 90 days?
Yeah, probably 60 days.
60 days?
60 days, really?
November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can.
That's getting
11/21,
way too
and that
far
would be
out.
for a status regarding tracking order and discovery and any motions.
I bet they set something before then. But November 21st, 2025, for the next status conference and hearing. A lot's going to happen before then, I would imagine. And if they are ready to hear motions on Karen Reed's motion to bring in all of the other defendants, they could put this on calendar sooner. So.
Rule 15 motions to amend, that type of thing, or bring in third parties. Okay. All right.
Oh, no, he said he'll hear that then.
Thank you,
Okay.
Honor. Have a nice day.
I think that's right before Thanksgiving. I think Thanksgiving's the 27th. So right before Thanksgiving.
All right.
Okay. I'm just going to leave this. I'm going to let this roll while everybody gets out of court just to see. And then we will go to Q&A. All things said, that hearing moved along pretty quickly, which is nice. A motion to dismiss is exactly what it is. I know a lot of you are showing your own incredulity with some of the arguments here. But again, I think Karen Reed's also having some incredulity with the arguments that were made here. But then again, the lawyers are lawyering. Just the lawyers are lawyering. Some of you have said they talk to the press outside. Well, we will. I don't know if this feed talks to the press outside. I'll go look for it real quick. But this is going to be a very long journey, like a very long journey. So let me see if this picks up outside. Otherwise, I will switch. No, this feed ends. I will switch feeds. Give me 1 second to go look and see if we have one where he speaks up. Probably the Court TV feed, so I'll go grab that. And then we'll summarize this. It's going to be a very long journey. Very long journey. Let's see. My weather today is going to be a very long journey as well. So all of you keep an eye, depending on where you live. We definitely have some more spicy weather coming through. Woke me up at 3:00 this morning, which is not ideal. I definitely don't want to be awake at 3:00 in the morning with the thunder, lightning, and the thunder. Nope, not on that feed either. Okay, let me look at one more. If I look at one more feed and don't find it, we're just going to move to Q&A, and then if we see it, we'll grab it later. But let's see. We'll find it. We'll find it real quick. Well, we'll see. So yes, we definitely have some spicy weather. I don't see it on that feed either. All right. I looked on 4 different feeds. I didn't see it at the end unless it is a separate feed. Let me see real quick if it's a separate feed. Ted Daniels have it. Thank you, chat. I'll go look over there because then it's probably on a separate feed than the NBC 10 feed. One would think it would just be at the end of their feed, but I guess not. If they talk outside of court, just leave it on the end of the court feed. I have no... Let's see if it's at the end of this feed. I don't see it at the end of the NBC 10 feed either. All right. I will look for it later. And you guys, if we need to just pull it up tomorrow, we'll pull it up tomorrow because it is not readily apparent in any of those feeds, but we're streaming tomorrow. So we'll answer Q&A and then we'll go from there. I thank you all for the new clickety-clackety love on the new keyboard. I love the new keyboard. I don't know what that is. But I love the new clickety-clackety keyboard. Let's do a quick summary of this. We'll look. I'll let producer Miggy look and then let me know. And let's see. We'll do a summary. We'll get to questions. We'll see if we find it. So at the end, we should just... At the end of the civil hearing, it actually moved along pretty quickly. And the court advised the parties at the very end of the hearing, look, civil litigation is not criminal litigation. The standard is different. Nothing will bring someone back. Civil court cannot appropriately undo the harm that is done. The best civil court can do is apportion some amount of liability and some amount of money to the person who's liable for doing the thing. And the court strongly urged the parties to have that conversation with their lawyers. Look, talk about the fact that this won't even go to trial till 2027, possibly 2028, especially if Karen Reed's attorneys bring in 10 additional parties. There are already 8 parties in the civil litigation. Karen Reed's attorneys are talking about bringing in 10 additional parties to this litigation. If that happens, then we have a whole lot more depositions, discovery, and the rest of it. So it's going to take time. Civil litigation is arduous and expensive. And if the goal of this civil litigation is answers, then it is going to be extensive, expensive, and long. We are not going to have swift resolution of this case. And the court did indicate that he wanted all the attorneys in person to have a conversation about this case, which is why Karen Reed had 7 attorneys appearing in court. The court did say at the very end that he wanted all the attorneys in person, offered to have this case on Zoom at the next hearing, and then it was determined that the next hearing will be in person in November 21st, 2025. So this case is going to take some time. We will cover the goings on in filings in between if we are not covering other trials. So we will tune back in. I don't anticipate that I will cover everything the second that they drop, because it's going to be a years-long process. So as things come out, we will cover them. But the bars that are being sued can settle separately from Karen Reed. So if the Waterfall and CF McCarthy's insurance are like, y'all, everyone at trial said that she wasn't intoxicated. How are you going to prove that we overserved her? Can we just settle it out and we'll turn over our discovery to you? So here's the discovery. We'll cooperate with you. We're not paying you anything. Just remove us from this litigation. Sure, they can absolutely do that. Different plaintiff parties can settle out. Will they? We don't know. Is it likely? Not at this point. Much will happen. The thing I'm most interested to see is Karen Reed sues everybody. That's what I want to see next. How is that going to go? Is Karen Reed suing Canton, Canton, Massachusetts State Troopers, Brian Albert, Nicole Albert, Jen McCabe, Matt McCabe, Brian Higgins, Tully, Buchanan, and Proctor? Is that going to be part of this trial? Is that going to be a separate but related case? And I imagine that if those parties are added in, and the defense here, Karen Reed's defense, has made an argument, look, based on the arguments being made by the plaintiffs here, we have to have these parties to have the entirety of the facts attributable and presented in one case. And we can only do that with all these parties. So like Karen Reed sues everybody means that the fight over discovery is going to be extensive, because then you get to depose Tully, Buchanan, whoever's designated from Canton, whoever's designated from state troopers, Proctor. Do you think Proctor is going to fight that discovery? Fuck yeah, Proctor's going to fight that discovery. So is everybody else. Jen McCabe, Matt McCabe, Brian Albert, Nicole Albert, all of them are going to fight discovery. It's going to be so much work. But it'll be really interesting to see how the court arranges those lawsuits, if they will all ultimately be heard by one jury or not. But if 10 additional parties are added with all the litigation fights over discovery that I would anticipate, it will push this case back much further. So I can understand where John O'Keefe's parents do not want their case almost overtaken by Karen Reed sues the world. But I can also understand where Karen Reed is coming from, saying, they're saying I did all this. And the only way I can show you that I didn't do all this is to also show you the rest of this. So you would end up with the O'Keefe parties versus Karen Reed and the bars, and then Karen Reed versus everyone else I just named. It will be extensive. Absolutely extensive. Very curious to see what the court does. The court has pledged his words. The court said pledged to get his ruling out in short order. So does that mean within the next 60 days? Yeah, that's what the court means. Within the next 60 days. Y'all, this is going to be a very long road. For all of you that started following the Tom Girardi case, when I started following that, we started talking about Tom Girardi in this case in 2020. And we covered the Girardi case until 2025, and we're still not all the way done yet. So we have covered all the way through, but there's more happening in the Chicago case that I keep like piling up, waiting to put into a podcast episode. And it's like double Dutch. There just hasn't been a time to jump in because so much else is going on. But this is going to be a case like that where we are going to be covering this for years to come. So just put this one on the docket. We're just going to be checking in with Massachusetts ad infinitum. Just forever. We're going to be spending some time in Massachusetts forever. So grab a lobster roll and, get ready to pack your car at Logan, because it's going to be a lot. Also, all of you that go down the Cape, is the only acceptable vehicle to drive down the Cape a Jeep? I have questions. Everybody in a Jeep, like beep, beep. Everybody's got, it seems to be the only vehicle that is acceptable, except maybe a golf cart. But like beep, beep. Laura M said, we need return tickets for Boston on EDB Air. No, one-way ticket, y'all. One way. We're escaping real life to Massachusetts. But why are there Jeeps everywhere? Why are there Jeeps everywhere? Jeeps everywhere. I need you to explain. Wait, they're allowed? Ocean Beach said they drive on the beach. You're allowed to drive on the beach in Massachusetts? California would literally never. I didn't know that. You can drive on the beach. Yeah, California would never. Or at least Southern California would never. I don't know what NorCal does. It's a whole separate place. Okay, because they drive on the dunes. I had no idea. Well, that makes sense. That makes sense. All right. Shall we continue? We shall. It's time for questions. You've got questions. I've got questions. And we're streaming tomorrow, so don't worry. We're also streaming tomorrow. So we will talk about things. If there's anything to wrap up from this case tomorrow, we'll do it tomorrow, because we're going to get to Q&A, and then I've got just kiddo stuff we've got to do. I feel like I just keep saying this. I don't know when it's not a busy phase in life, but it just keeps getting busier and busier and busier. But let's get to questions today, shall we? I turned that down way too low, you guys. There we go. A lot of you have asked the number one question, I think, well, one of them. I can't say number one because it's just based on how frequently I saw it. A lot of you asked, why aren't they suing Colin Albert? Probably because he's a minor. And they're suing Brian Albert and Nicole Albert, but they're not suing Chris Albert and whichever one Chris Albert's wife is, Colin's mother. But they did not name Colin Albert. We're going to have to wait and see when the lawsuit dropped, but probably because he is a minor. So when some of you are saying he's not a minor, he might not be a minor now, but when all this happened, he was a minor. So unless they think he wasn't there at the time, but he was a minor at the time that this happened. But we will see what they do when they actually file it. They might bring more people into it, but they might also have the digital evidence that shows that he left. I don't know. I don't know what they know. So, and we saw evidence at the trial and testimony at the trial that Colin had already left. So I don't know. So we'll see what they choose to do. I trust in very few things at this point, but I know for a fact that Karen Reed's attorneys, A, there are many of them, B, they are smart, and C, they have way more information than we do. So I trust that they will have it handled, right? So the choices that they make are the choices that they make. So let's get to your questions. I saw a couple people in the chat said, wait, EDB, what's MCR? The band My Chemical Romance. They're going back on another leg on tour. I can't talk about it because I have such mixed feelings, and it is so hard to plan for what life looks like next August, because it's really going to depend on so many unknowns. And I have so many unknowns in my life on what next August looks like based on my kiddo. So I have no idea. But I will say MCR in Nashville is after DCI finals. I mean, is it going to be, well, T needs to be in college? Who knows? I don't know. Where is T going to college? I don't know. It's still September. I just want to decorate for Halloween and eat everything pumpkin spice. I don't want to think about it. It's too much. Dude, senior year is too much. It is so extra. It was like Travis's last homecoming dance and all of it. It's too much. But do I want to go to MCR with my kiddo again? 100%. 100%. Do I want to go to the Hollywood Bowl? No. No, I don't. But yeah, I'm going to go to some more MCR shows. And it wasn't lost on me that this tour is called the Black Parade, not Long Live the Black Parade. We are going back to Drog. I cannot wait to see what happens. I am so down a rabbit hole of the MCRU. I love all of it. I love all of it. I'm fascinated. I'm here for all of it. It's good to see you all. We have some updates coming for our members, so hang in there. We've got some fun stuff for you guys. So, saw Corn yesterday, EDB's genre. It was fun. I love Corn. Like the food I like popped or like Mexican street corn, but Corn the band, 10 out of 10. 10 out of 10. 10 out of 10. Michelle V, good to see you in Long Beach. God, I love the LBC. I love it. Alice, thank you for the gift of memberships. All of the members, congratulations. I love seeing your member celebrations. We've got some fun stuff coming up for our members. Matt the Future ESQ, good to see you in the chat. I can't wait for the tea. Karen sues everybody. Like, we knew it was coming. You could anticipate that it was coming. It's different to hear her say it. It's different to hear her lawyers be like, so we're just suing everybody. So for all of you who are just quoting Freak on a Leash, Riley said blood for the blood god. Thank you, Riley. I appreciate it. Mimi Chip said I got to work with the producer of Freak on a Leash recently. Absolutely amazing. I love Freak on a Leash. I look, man, it was such a good time for music. It really was. I miss it. I could rant about the music industry killing music forever. Money has changed. Advertising has changed. I hope that we see more artists just going direct to consumer because they can, because distribution channels don't have to be controlled. But it's really difficult to watch, the music industry be like, okay, we'll give you one song and see how it goes. Artists need time. And I realize that that's expensive. I have so many thoughts about all of it, but I hope that we get to a point where we see artists getting the time and space to make art. But if I could rant about commoditizing art forever. there is such a tension between artists making something that they love and making something that their labels want them to make because it's commercial, and the tension of the two, and how to find audience in that now. It used to be easier, I think, but finding audience in that now is a whole different thing. And it's just, it's so much. Lori and CT said, I watched the Lilith Fair doc. I didn't know there was a documentary. I love a music documentary. I love a music mockumentary too. Geez, Spinal Tap. Wondered how I missed going. Lilith Fair always seemed amazing. I did not go to many big festivals. I still am not a huge festival girl. There are still times that even for the extroverted me, going to the huge stadium shows still give me a little anxiety. Like if everybody would just play the Ryman, my life would be so happy. But also tickets at the Ryman are like $40. There are so many great venues here. I just love it. So love Gerard Way, and Umbrella Academy was so awesome. I love Gerard Way's work in comics too. Look, I could just fan forever. Some of you were like, are we talking about law or music? Both. We were talking about both, but festivals are not my vibe. Not my vibe. Debbie said, I have never been to Nashville, might have to go for MCR. Look, there are plenty of places where you can stay that are walkable to Nissan Stadium, because I don't think new Nissan Stadium will be open by the time MCR comes through. The concern with shows in Nashville is weather, and there have been numerous shows in Nashville at Nissan Stadium. They are building a new one, but at Nissan Stadium where weather has canceled the show and people have had to travel back in for the show. That is always an issue. I also saw them in Tampa, loved the Tampa show. It was incredible. So I was running around. My face was bright red. I was so hot, but it was great. Loved. This guy is getting growly. I hate that I have to go to work. Angie, I get to do this. So I love that I get to go to work. But yesterday I had to deal with all kinds of like businessy business stuff. And Judge Abby called on her way home. She's like, how you doing? I'm like, I am knee deep in paperwork. I am doing paperwork. I am doing the work part of the things that I don't love. This is the work part of the things that I do love. And then when I stream too long, I don't do the other work stuff. And then I end up doing it at like 11 o'clock at night. And then going, I need to go to bed. Dawn the Sleepless Hag, that's hilarious, said, I know the feels. My daughter graduated 2025. Son is in choir, band, theater. That's busy, but that's amazing. But yeah, the like senior year is it's a whole thing. 7th grade's a whole thing. Scooby-Doo, as they like, I don't know. It's different depending on, like, as Griffin goes through milestones, it's different because it's like, he's my youngest. And it's so different. Like, as the oldest is doing things versus the youngest, because it's like, as T's doing stuff, I'm like this is what T's going through, but I'm excited for him. But also, by the time we get to the youngest graduating, I'm going to be like, I don't even know what to do with myself. Then again, social media keeps feeding me parents that are like, I'm just going with you to college. And I'm like, I understand the feeling, but my kids need their own space. And then I'm going to be like, but you guys can just come back here. Like, go to college, but like, just come back here. Just come back here. Just come back here. We've got this. So I'm all about it. So, Angel, good to see you. Thank you from Bulgaria. Good to see you. Some of you in the chat were like, just bring the laundry. Exactly. I'm like, we have snacks. Come home and visit. BT, question, can they explore the garage now? I imagine there will be some difficulty based on the fact that the house has been sold. But whatever evidence they have closer in time may become relevant in the civil case. So there are some doors that may open up. Gris asked, is Carrie on the to be sued list? I did not hear Carrie's name. Carrie was not in the house at 34 Fairview that night. So that's what it is. So, we'll see. A lot of you, I'm going to answer a few more questions and then we'll go grab that interview. How's that sound? And then I'm going to have to bounce, but we've almost 3 hours. I'm trying to keep our daily lives to a reasonable clip so I can get other work done, which we'll see. Let's see. Hazel said, who failed to supervise Proctor? I think Tully and Buchanan were in his direct line of supervision, but that's coming out more in the Proctor hearings. The Proctor hearings are resuming, I think, in October. I don't have it in front of me, but when the Proctor hearings resume, we will cover them. If we want to cover the full days of the Proctor hearings and cut out the pauses, we can do that. I did a summary of it on the Emily show, but we can look at those Proctor hearings. I might do those closer in time to the other hearings because there's also some other trials coming up. And we still need to go back through and do like a speed run of the Cardi B case. We have lots to do. There's lots and lots. Perry Monopause Princess says AJ didn't join the team just to settle. I mean, AJ is pretty intertwined with all things going on, including the, I imagine, books, the TV shows, and the rest of it. But AJ has all the knowledge from the criminal case. So you absolutely need him on the team. I don't think we're going to hear him in court very much, but yeah, he absolutely is. I think they granted all the pro hoc vices. He's absolutely going to be a part of this team. So yeah, I think we will see the influence of AJ being part of the team. So let's see. Josh H said his argument is why the other 10 parties are needed 100%. SF asks, how do we know that the niece's statements haven't been influenced by what the family believes happened? It is, well, I don't know when the niece was initially interviewed. Those initial interviews will come into play, and some of it's going to go on Karen Reed's own memory too. But those are things that just have to be questioned. The niece has also testified at 2 trials now, so we're going to get that. So we'll see. But we will go. Miguelina is telling me it's like a 3-minute interview, so we'll go grab that before we bounce. Minnie said, I don't think she should settle. I get it. There are many reasons people settle, but as to some of the, I would look at all the parties differently. And like, do I think Karen Reed and Paul O'Keefe are going to settle? No. Do I think there's room for Karen Reed and John's nephew to settle somewhere? Maybe. Do I see room for the corporate bar establishments to settle? Yeah, that's going to depend on their insurance companies. So it really just depends. So we could see a very different case a year from now, depending on who's in and out of this case. But we can end up with a different makeup of the plaintiffs and defendants down the road. 100%. So not all the plaintiffs have to go forward. Erica, I wanted to send congratulations and all of the warm thoughts. Erica said, Emily, I'm in the hospital to have my baby boy today. Baby John will be here before we know it. Congratulations. I hope that everything goes smoothly. Remember, Erica, now that you are, and I am imparting unasked for advice that I think everyone needs, and it is real easy to forget. The wee ones, when they are fresh, are not on a normal time clock. They are operating on a 24-hour time clock. So when you sleep is not really related to any clock other than baby's clock. So sleep as much as you can. It's okay to say no when you need space. It's okay to say yes when you want to see people. Everyone will be very excited. You will be very exhausted. It is okay to tell people to wait. It is also okay to say, just drop food at the door. We'll go get it. It is okay. Set your boundaries. It's fine. Everyone's excited. You don't have to accommodate everybody. Take care of yourself. Give yourself space. Sleep as much as you can. And it's all going to be fine. It's all going to be fine. It's all going to be fine. Just take a deep breath. And if anyone gets all sideways about it, because well, Travis was premature, so was Griffin, but less so. We set a lot of boundaries, and some people did not love that. I'm like, look, my role is to take care of me and this little one. It'll be fine. You'll be around in a month. Just take a breath. Not everybody needs to be around. And as we are getting into respiratory illness season, it's okay to ask people to take care of that before they come and see you. It's okay. Take care of you. Take care of baby. Congratulations. I give you permission to set boundaries. And if you're exhausted, it's okay to tell people, I am too exhausted to see anyone's face. Do not face at me. Also, it's all going to feel like a blur. Just enjoy it the best you can. Take the quiet time with you and kiddo. It's fine to want that because, gosh, when everybody wants to be around, it's a lot. Some people love it, but I just wanted to be like quiet. I'm like, please just let it be quiet. So just ask for what you need. It's all right. You don't have to accommodate everybody. Accommodate you. I saw a couple of you saying, MJJ in the chat said, I had a preemie during flu season. We isolated for 2 months. Exactly. Lexi in the chat said, so jealous. I have a whole 4 weeks to wait for my baby. Babies have their own time clock, but yes. A lot of congratulations, a lot of well wishes. And yes, it is okay to have boundaries. Lissy Ari said, I wish I knew boundaries when I had my son. It's really hard because other people's expectations can feel very heavy. And a lot of those expectations come from excitement, right? And just because they're excited doesn't mean it's what's best for you at the moment. So it's okay to say, we need a minute. But it feels like a blink. I'm going to get all emo about it, but it feels like a blink from being in the hospital to like, I can't plan concert season because my kid needs to go to college. And I don't know when he's going to start school. So how do I buy concert tickets to plan when school is being started? We're going to hope for the best. The days are long. But the years go fast. Time is a construct. So enjoy it. Enjoy every phase of it. And some phases are harder than others. And when you end up inevitably with all of the bodily fluids on you, you just have to laugh and take a shower. It's going to be fine. Just, it will all wash. It will be okay. It's gross, but it will be okay. You start to learn what love is when you're like, you might learn in college depending on your friends and their tolerance for whatever they're up to. You're like, I really like you because I am still here with you with all of this happening. And then when you have your kiddos, you're just like, I am still here. And then when you are a caregiver for others, you're like, I've got it. It's fine. Somehow it's different when it's your kids. I don't know why, but somehow it's different. So with all of that, T-Rex asked what would happen if someone passes away during civil litigation. We have seen this in other cases that we have talked about, but civil litigation can go on. It would just swap in other estates. It doesn't really change things out. Criminal litigation or criminal cases, it matters more. Civil litigation, estates can continue with their lawsuits. So it doesn't change things too much, but I hope that doesn't happen. Of course, civil litigation is long and stressful, and I hope everyone is able to resolve this and move on, sooner rather than later, but that's not going to happen, right? I wish this would resolve sooner rather than later. Monuments of Speculation, good to see you in the chat. All of the law nerds, it's good to see you. Let's pull up that after court chat that so many of you asked me about. We're going to go grab it. Thank you, Mingalina, for going and finding the link when I couldn't go grab the link because we're streaming. So it makes it a little bit harder, but we will go grab that from after court. I have no idea what this is going to sound and or look like, but we'll see. We'll just give it a shot. Why not? Chat asked, chat received. Chat asked, chat receives. So let's go look. It's about 3 minutes. Let's go look at the media pool following the attorneys outside of a different courthouse than last time, because different courthouse than last time. Chat, your motion has been granted. If this is all Blair Witchy, which I suspect that it will be, just Hold on to your motion sickness until everybody stops walking. I hate these media scrums. All of this stresses me out. It just, it stresses me out for the lawyers. Like seeing someone, I'm glad we have it. I'm not saying that, but seeing like people trying to like crane those giant media cameras over an attorney, all of it stresses me out. Watching it stresses me out. It all stresses me out. I hate all of it. It's so stressful.
Poor girl.
Right?
I think we're a little offensive during the criminal trial.
I couldn't hear what the question was. Hold on. Let me make sure. Oh, there we go. The closed captioning.
Poor girl.
Right?
I think we're a little offensive during the criminal trial.
How does that work?
I need a fullback.
Karen said, I need a fullback. Accurate. Accurate. You do. Because those scrums are so, I can understand the discomfort of large cameras moving towards you, plus all the microphones. It's a lot.
But y'all didn't even let her get a blocking back. My lord. We can move quicker. Alan, can you help me understand what the
The media's like, move quicker. And she's like, dude, all of you are chasing me. It's a lot. If they're going to talk after court, they're going to have to set up a designated location.
claim is? What an affirmative claim is? It's an affirmative claim against third-party individuals. That's exactly what we intend to bring.
Another lawsuit. So Jackson is saying it's an affirmative claim, not an affirmative defense. We are bringing new causes of action. So we are bringing an additional lawsuit. It might be part of this lawsuit. It might be separate.
Fine, to save the court time and money.
All the same individuals are involved. So that's exactly right. It's a matter of judicial economy.
Your response to the fact that the judge might take longer if you do this, you have all these.
Well, of course, because it becomes a bigger case, more voluminous, right?
They said, can you explain why the judge said it'll take longer if you do this? And he goes, right, because it's a bigger case. Right, because Proctor's going to make, and everyone involved, not just Proctor, but everyone's going to be like, I don't want to be deposed. This is going on. This is going over here. This is going over there. But if you've ever wondered what it looks like to affirmatively have a lawyer act as your sword and your shield, did you see that Jackson just stepped in front of the media and started asking questions so Karen Reed could move out of the back? Like that is 100%. That is 100% what you want your lawyer to do. To be like, no, I got you. Right? I can answer those questions.
Bigger case with more claims. And that's exactly what this case calls for.
How did you determine
the days of Karen Reed being on the defense are over, right? That's what started today. That's what we're seeking today.
He's like, we're going to bring it, fuckers. All of it. All of it. It's been brought in. Karen Reed is no longer just a defendant. She will also be a plaintiff. That's what we're bringing today. So she will also be a defendant, but she's also going to be a plaintiff. So bring it on.
The judge say, trying to resolve this. Can you resolve this out of court?
Every single civil case should at least have that on the table. Civil cases are built and designed to be resolved. If they can be, we'll see. We'll see. It depends on how reasonable the other side is.
Was that something you guys would like to do, though? I mean,
that was a classy move for AJ. They asked him, do you see this case settling? And he said, civil cases are designed to settle. It depends on how reasonable the other side is. A very classy answer, right? Depends on the other side. We're here to be reasonable.
Is that something that you guys would like to do, or do you want to make a point?
Anytime there is a civil case, look, civil cases are not about making a point. They're about trying to
resolve,
the truth, right? And that's what Karen's going to do with this civil case. We're going to try to get the truth out there. Like I said, the days of her being on the defensive, those days are over.
So you said
everything that you heard in there was basically parroted. Every single word that you heard in there was basically parroted right from Michael Morrissey, right from the prosecution.
Oh, I thought he said parody. At first, I was like, everything you just heard in there is parody. I'm like, a parody of what? The reality? No. Parroted. He's saying everything you heard from the O'Keefes is parroted from the prosecutors, which all of you called because all of you were in the chat saying, why does this attorney sound like he's just making the arguments that Brennan was making? Right.
They lifted it right off the prosecution's closing argument. And maybe somebody should check the tapes. Because last time I checked, those arguments were put forward in front of a jury, and the jury spoke very, very loudly.
Yeah, the jury
not
went, nah.
guilty, and not just not guilty when the jurors were asked, innocent. Those claims are false, and they were proven false, and they will be proven false again.
I can't move the closed captioning enough. Sorry,
should this
chat.
case be resolved? We're always open to resolution. We'll see. We'll see. It depends on how reasonable the other side is.
We
gotta go.
Damon, did you want to say anything?
We gotta go.
Sort of point person on this, or?
Well, Alan says it all as in his perfect way.
Alan says it all in a perfect way. I think it would make sense for them to pick a point person with the media and just say, okay, I'm handling court. Alan handled the media. We've got a plan. We've got to go.
So, what we're trying to do is make sure that Karen is well defended and that the claims that we have to pursue for her affirmatively are brought in the same proceeding in the most efficient, judicious way so that her day in court is fully and fairly adjudicated.
But if you combine these cases, isn't that unfair to the O'Keefes?
Not at all. Not at all. Part of her defense is that somebody else put her in this situation. And so that's when
The question was, is bringing all these additional parties into this case unfair to the O'Keefes? And he said, not at all. Part of the defense is that someone else put her in this situation.
I said it's not your typical wrongful death action. Karen Reed is in this situation because of the behavior of others. And as Alan said, she's no longer on the defensive. She's going...
Oh, the closed captioning got Alan's name right that time. So I think we're going to see Alan and Ellen used interchangeably.
Affirmatively, and we're trying to put all the evidence, all the parties, all the claims in the same proceeding. Because
how did you decide on who to name in the counterclaim?
I'd love to tell you that.
That's strategy. I'd love to tell you that, but you're going to have to... Well, you're going to have to wait and read the complaints.
But it's really sort of a litigation strategy point. So unfortunately, I cannot get into sort of discussions behind the scenes.
So do you plan to prove that someone else killed John O'Keefe?
We plan to show that Karen did not.
But that's not the same as proving
a
someone
very
else
good
did.
answer.
We're going to let...
I don't know who's asking the question. Man's not required to prove who did it. Man's required to prove that Karen Reed is not liable. He doesn't have to prove what happened. He has to show that she is not liable.
Evidence play out. I'm not able to tell you that yet, but I can tell you that she did not.
How about, can you spell your first and last name for me?
Sure, Damon, D-A-M-O-N, Seligson, S-E-L-I-G-S-O-N.
Thank you.
All right, well, thank you, Damon Seligson. There we go. So let me make sure nothing auto starts. I love that YouTube is like, hey, you were watching YouTube. Would you like this other YouTube video? It's you live. We can YouTube Inception. So, I mean, we heard what we heard before, that the lawyers have a strategy, and the focus of Karen Reed's civil defense is to make sure everybody's in one case. So if any of it's coming out, all of it's coming out. Just literally, we have entered. Where did it go? It's been a minute. I feel like I haven't streamed in 100 years. Hold on. Where did I put it? Oh, no, that's not it. You guys know what I'm looking for. Where did I put my mention at all? Did I lose my mention at all? No, it's right here.
Mention it all. Mention it all.
That's what the defense's strategy is. If this is going to trial, everybody's going to trial. And we are going to go from name them to mention it all. That's it.
Name them.
So, what's going to happen with the Karen Reed civil case? Well, at this point, it's going to take forever. I don't think we'll see a trial in this case before 2028 if the defense is able to bring in the additional parties. Though the court is allowing a pool camera in the courtroom. So it seems that we will be able to go along with these hearings and follow along with the proceedings and see what other information comes in. Because I think at this point, we're all just invested in figuring out literally what the fuck. Like, what? And in the course of the civil case, we will see more information, I suspect, than we did in the criminal case. The criminal case has different parameters, boundaries, and rules. The civil case has different parameters, boundaries, and rules. And the burden at this point is on the O'Keefes because they are the ones suing Karen Reed. But it seems like that's not going to be the state of this case for long because Karen Reed, through her attorneys, has said she is also going to sue everyone. So I am sure, well, we know that Proctor's lawyered up, but he's going to need additional attorneys that aren't dealing with his employment litigation. But Higgins, Tully, Buchanan, the McCabe's, the Alberts, everybody is going to need to be on the phone with their attorneys because, well, litigation is coming and it's not going to go away anytime soon. So, Law Nerds, we will be back tomorrow. We'll see what happens with this. We'll see what happens the rest of the day, and then we'll decide what we cover tomorrow. There are so many things in the hopper that I'm just not sure. Tomorrow's gonna be just based on vibes. So I'll let you know, but I'll see you tomorrow. Just if you have the Law Nerd app, then you'll know when I'm streaming. But when we are on a normal schedule, we stream at 11 a.m. Tuesday, Wednesday, Thursday. When we're in trial, well, everything gets thrown a little bit asunder, and I don't think we will be in trial until we get in live trial until October. But we do have some Cardi B case that we're going to speed run. We're not going to watch every minute of every witness, but we are going to watch some of the Cardi B case. I just need to figure out when because I'd like to do it all at once. We might just do that for the entirety of next week, so we'll see. But don't worry, Law Nerds. We'll just be back streaming tomorrow. We have much to talk about. It's just sorting out what goes first and where. So for all of you, thank you for being here. Thank you for being a Law Nerd. It's always so good to see you. Law Nerds, you are the best. Thank you for being the best place to stream on the internet. And I'm going to keep saying it during stream. Thank you, YouTube, for letting us get rid of the leaderboard. I couldn't be happier. I really couldn't be happier. Yay. I'm so glad. I'm just so glad. So with that, it's good to see you guys. I will see you tomorrow. Take care of yourselves. Take care of each other. Don't forget to hydrate. And hopefully your weather's not too spicy because it's that time of the fall. All right. See you tomorrow. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.